All right, this is January 25, 2018. This is the January session of the Code Enforcement Special Magistrate regarding code enforcement agenda. First item we have is case CE 17-002716. Respondent is Lysandra Maldonado. The address is 1333 Harrison Street in Oviedo, parcel number 11-21-31-5-000-0030. The alleged violation by the city is violation of Section 4.11 of the Land Development Code, parking a wrecker on property. Who is here to speak to that item today? All right, would you step forward, please, sir? Who else is here? Yes, anyone who's going to speak today, please step up to the microphone. All right, first state your name clearly for the record and into the microphone.
Lysandra Maldonado.
And, sir, into the microphone.
Jim Orioles.
All right, would you both raise your right hand? Do you solemnly affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Orioles, we'll hear from you first, and then Ms. Maldonado will hear from you. If you want to be seated while he's talking, that's fine.
Good morning, Your Honor. Jim Orioles representing the city, case number 17-2716. I have 11 pages of evidence to present to Your Honor, if I may approach the bench, and
Yes.
I've also supplied the same packet to the respondent.
All right, thank you. This will be received as into evidence as the city's exhibit consisting of 11 pages. All right, go ahead, sir.
First page, Your Honor, is the property appraiser sheet showing the ownership of the property is in fact Ms. Maldonado. The second sheet is the Section 411, the code that we alleged has been violated. The third piece of paper is the original notice of violation that was sent on October the 2nd, and the record was there for 9 days, I believe. The bottom of the notice of violation says, pursuant to Florida State Statute 16206, if the violation recurs or if the violation is not corrected by the time specified for correction by the code inspector, the case may be presented to the special magistrate even if the violation has been corrected prior to the hearing, and the notice did so state.
Mr. Orioles, let's come mic, please.
Okay.
The next item is the certified mail receipt and the signed green card for the notice of violation. On November 20th, on a routine inspection, we noticed the wrecker was again parked in front of the property. I have 2 pictures showing that. That was the only day that the wrecker was parked on the property.
November 20th?
Yes, sir. That was the only day it was observed on the property. We honestly thought that it would be there for much longer time, but it was only there for the one day. So we sent the affidavit of violation request for hearing and a notice of hearing, certified mail receipt, and Ms. Maldonado signed, or someone signed for it, and Ms. Maldonado is here. And what we would request, Your Honor, for this case is that the records show that the wrecker was in violation for the one day, and that any further violation of that code by those owners would be a repeat violation.
Okay. So I thought I heard you say earlier 9 days.
The first offense.
Okay.
That we sent the original notice of violation for back in October. I mean in yes, October 2nd.
Okay, so it was there 9 days before it was moved?
Yes, sir.
All right, we don't have photographs of that.
No, sir. It was required to be gone in 10 days, and it was gone in 9.
Okay. So they moved it by...
They moved it prior
before
to
the date set for compliance.
Yes, sir. Yes,
but
sir.
then you rechecked in November and it was there again.
Yes, sir. Yes, sir.
Okay.
But we're not requesting any fine at this time, just that the next time will be considered a repeat violation.
All right. Ms. Maldonado?
Hi, good morning.
Yes. Just please speak into the microphone.
Okay.
Okay, what do you have?
Okay, the reason the tow truck was in the house was because my husband works overnight 24/7, and if the tow truck was there, it's because maybe he was either eating something, taking a nap, like Oviedo towing guys do. I mean, we have like an Oviedo guy that works for Oviedo towing, few houses down my house, and he does the same thing. He just park in front of the house and take a nap. I mean, these guys need to rest. So if the tow truck was there in the property was because either my husband stopped for a quick snack or, nap or something. But we pay $80.25 to Oviedo RV, and that's where the tow truck is 24, every day after he's done with his job.
All right. All right, anything else?
I do apologize for that, and it won't
Okay.
happen again.
All right, the city has not requested a fine today, and I probably would not at this time have imposed it anyway, but I will enter an order to the effect that any future violations will be repeat violations. And the significance of that is that the fine doubles with a repeat violation. The next time the city may be seeking a fine. Okay. Thank you, ma'am.
Thank you.
And no cost have been requested by the city, and none will be awarded. All right, thank you. Next item on the agenda is case CE 17-002385. The respondent is U.S. Bank. The property in question is 123 East High Street, Oviedo, Florida 32765. Parcel number 15-21-5-31-5-0000-0080. The alleged violation, there are many. It's alleged violation of Section 2219 of the Land Development Code, prohibiting open storage. Section 22-144, public nuisances. Section 22-173, overgrown nuisance lots. Also alleged violations of the International Property Maintenance Code, which has been adopted by the City of Oviedo. Section 301.3, regarding vacant structures and land. Section 302.1, sanitation. Section 302.5, rodent harborage. Section 302.7, accessory structures. Section 303.1, swimming pools. Section 303.2, enclosures. Section 304.4, structural members. Section 304.6, exterior walls. Section 304.7, roofs and drainage. Section 304.13, window, skylight, and door frames. And Section 304.18, building security. And the allegation is allowing the accumulation of high growth, allowing fence and shed to remain in a state of disrepair, keeping pool unsanitary with stagnant water, enclosure not secure, trash and debris, broken windows, doors not secure, soffits rotten and falling down, and rodent infestation evident. I would add, based upon past hearings, that there's possibly also a violation of the Municipal Code 22-144 C5, which deals with stagnant water in pools. Anyone who's here to speak to that today? All right, Mr. Orioles? Anyone here on behalf of U.S. Bank?
No, Your Honor.
All right, Mr. Oils, would you raise your right hand? You solemnly affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
I do, sir.
All right. I'm assuming this is probably a bank repossession.
Yes, sir. Yes, sir.
Okay. Go ahead, Mr. Oils.
Case, Jim Orioles representing the city in case 17002385, 123 East High Street. Your Honor has enumerated the numerous violations. I'm not going to repeat them for the sake of time. I have 32 pages of documentation to present, Your Honor, if I may approach the bench.
Yes, please. All right. I'm going to receive these 32 pages into evidence as the city's exhibit. Go ahead, Mr. Orioles.
The first document, Your Honor, shows the ownership of the property is now U.S. Bank. We were not able to thoroughly inspect this property until it was taken over by U.S. Bank, and there was a representative from the property maintenance company there, so we could thoroughly inspect the property. The pictures that Your Honor will see indicate that we could. The next 5 pages, Your Honor, are the codes, the various codes that Your Honor read off that we allege have been violated by the property. The next pictures show on October the 20th the condition of the property, particularly the backyard. The front yard was not as bad, but as you see going through here, the pool was black and disgusting, the enclosure, the doors are missing.
The screen enclosure is broken?
Yes, sir. There was junk and debris in a property, which is shown in the last picture. The soffits on the one part of the roof are down, are gone, as it shows. Okay. There was various debris all over the backyard. It was high growth. It was like a jungle in the backyard.
Boy, that's the water in the pool?
Yes, sir.
Wow. Okay. Okay, go ahead.
On October 22nd, we sent a notice of violation to the bank, specifying all of the alleged violations. You'll see the certified mail receipt and the signed green card. They did get in touch with us by phone, and first of all, I don't know why, but it's kind of common in these foreclosure cases. The first thing they do is tell us somebody's living in the home. We knew better than that. There was no one living in the home. They did when they left. They trashed the place pretty good when they left. We went back out on the date specified for correction, and that's the next set of pictures that shows the tires, shows the pool. That was on, it was on November the 27th. It shows the debris, the jungle in the backyard.
The first set of pictures were taken when?
First set of pictures were taken on October 20th.
20th?
Yes, sir.
Okay. All right, go ahead.
The next set was on 11/27, where the violations were still there. However, at that time, it was evident that they were working on the property. They had secured the front door finally, and they were removing much of the debris. We did send out a affidavit of violation request for hearing and notice of hearing. We did not get back the proof of mailing, but, Your Honor, I've attached the printout of the sheet from U.S. Postal Service that shows that it was tracked by them, and the green card was signed.
All right.
The next set of pictures were taken this morning, actually, and there are still violations. There are 4 glaring violations still that they have not taken care of, but they have taken care of most of the rest. 303.1, 303.2, 304.6, and 22.144 still exist.
All right, go through those again. What, as of today, still exists?
303.1,
Okay.
303.2,
302 point,
303.2, 304.6,
wait, 30, I don't see 301.2. The first one you said it still exists is 301.3.
303.1,
And the second one,
303.2.
303.2, all right. That is both the fence and the pool screen?
Mm-hmm.
And that's as of this morning?
Yes, sir. 304.6.
Okay.
And 22.144.
All right, so
Now,
those still exist as of today?
Yes, sir. The pool has been drained, however, there's now, each time it rains, it gets a little bit more water in it. But the pool has been drained. The enclosure is, all the doors are missing off the enclosure. There's 3 doors on the enclosure that are missing.
On the pool screen?
On the pool screen,
3
yes.
doors?
3 doors, yes. The soffit is still missing on the east side of the house. You can see from the pictures. And what's left in the pool is now, it's still less than a foot deep, but it's black and coal, and it's still there. They have told us that they are actively seeking, again, they say that the big tree that fell down in the backyard is what's keeping them from proceeding. However, the big tree has been gone for over a month. So they are working on the property, and I believe they're being diligent in trying to rid themselves of the property. So they're working on it.
I'm trying to recall, have we seen U.S. Bank before me on other occasions?
I'm sure we have. I can't say specifically, but their name pops up quite a bit. But we may not have brought them before you before. We've definitely contacted them before, but I don't think we brought them before you.
Well, I continue to be frustrated by banks. They don't take the problem seriously enough to show up for these hearings. And really the most serious violation from my perspective is the pool screen enclosure in the fence.
Yes, sir.
And even though they've taken some of the water out of the pool, this is a public nuisance. It's an attractive nuisance for children. And sooner or later, we're going to see a child drown in one of these bank foreclosure pools.
Yes, sir.
It's just a matter of time. So I'm going to find today that first, as of November 27, the bank was in violation of all those sections enumerated at the outset of this hearing. I'm going to find that as of today, they're still in violation of Section 22.144 of the Code of Ordinances, that being that this constitutes a public nuisance. I'm going to find that they're in violation of the International Property Maintenance Code as of today, Section 301.3, Section 303.2, and Section 304.6. I'm going to order them to come into compliance no later than midnight of February 16th, 2018. If they do not, then a fine of $200 a day will be imposed for each day of noncompliance commencing on February 17th.
Thank you, Your Honor.
And in imposing a fine of that size, I've taken into consideration numerous factors. Number one, the fact that they haven't shown up, the fact that they've had ample time to fully correct this and they haven't done it, and most importantly, the danger posed to children in the neighborhood and to the public by the condition of the swimming pool. All right, next item on the agenda is case CE 17-002788. Respondent is Jeremy Barong. The property is 786 Lincoln Parkway, Oviedo, Florida 32765, parcel ID 16-21-531-0D00-002A. Allegation is violation of the Land Development Code, Section 4.11, prohibited uses and specific exclusions. B, prohibited accessory uses, parking a boat or trailer between the front building line of the house and the street. Who's here to speak to that today? All right, would you step forward? All right, first, one at a time, into the microphone, clearly state your name. Yes, sir.
It's Matthew Carpenter.
All right, and you, sir.
Jeremy Barong.
And,
Jim Orioles.
all right, would you all raise your right hand? Do you solemnly affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
All right, all have stated yes. All right, Mr. Orioles, we'll start with you.
Yes, sir. Jim Orioles, representing the city in case 17-002788. Your Honor, this first sheet, let me get ahead of myself. I have 16 pages of evidence to present, Your Honor, if I may approach the bench. And
Yes,
I've also,
you may. You've given a copy to
I've also
Mr.
supplied a
Barong?
copy to the respondent.
Okay. All right, this will be received in evidence as the city's exhibit. All right, go ahead, Mr. Orioles.
The first document, Your Honor, is the property appraiser sheet showing the ownership of the property to Mr. Barong. The second sheet is the copy of the alleged ordinance that was violated. The third sheet, Your Honor, is your finding of fact, conclusion of law and order when this property was brought before you in early 2017. The first offense was January 20th, 2017. On February 16th was
When
when
was the first offense?
January 20th, 2017.
Is there a photograph of that year?
No, sir. All I have is your finding of fact, conclusion of law and order.
Okay, I do remember, I remember the name, yes. Okay. Let me take a look at that for a second.
Sure.
Right, just a second. All right, so when was the first time the repeat violation was noticed?
The next picture, Your Honor, December the 4th, 2017.
So that was a repeat violation as of that day?
Yes, sir. We sent an affidavit of repeat violation request for hearing and a notice of hearing. There's next documents. The certified mail receipt was the next document, and the signed green card is the next document.
Okay. First, I want to find it's a threshold matter that all notices required by statute and ordinance have been provided to Mr. Barone.
Yes,
Okay,
sir.
go ahead.
The next several pictures, Your Honor, you'll see on December 5th, December 6th, December 7th, December 8th. The 9th and 10th were weekends, so we did not have inspections on those 2 days. December 11th, December 12th, December 13th, December 14th. The boat was still between the front building line of the house and the street. Inspection on December the 15th revealed that the boat was no longer there. As of this morning, the boat was still not there.
So
A total
we
of
have, we have photographs then for, let's see, 1, 10 days, is that
Yes, sir.
correct? All right.
9 days, Your Honor. 9 days photographs, Your Honor.
Okay. All right. Anything else, Mr. Williams?
No, sir.
All right. Mr. Barone?
My mail goes to a P.O. box, so I don't always get it right away. This is a rental property. I just want to say that. And then this is my tenant, Matthew.
Okay. Well, I see that you did sign for the notice on December 5, correct? That's why
I can't
the
confirm
certified
that.
mail receipt indicates.
It goes to a UPS store. Do they sign it? I don't think I signed it. I'd have to look back. I didn't.
Well, doesn't matter, somebody signed on your behalf.
Yeah.
Is this your signature?
No, sir.
Okay. Well, nevertheless, I find that the notices weren't properly given.
Yeah.
The city cannot be responsible for making sure you check your mailbox regularly.
Okay.
All right, go ahead. Yes, sir.
As Jeremy had stated, I'm the tenant. During the time that the boat was out front, my vehicle, we have a one-sole pickup that is able to move the trailer. And I know it's not really an excuse, but during that time, the driveline on the truck was inoperable. The vehicle was being worked on, and I was unable to move it until that time that it was fixed. Is the reason that it was in the actual driveway. Obviously, it wouldn't happen again, and I would beg for any kind of leniency I could get as far as fining goes, as I'll be the one that will ultimately be.
Were you the
paying
tenant
for it.
there back when I entered my first order?
Yes, sir, I was.
Okay, so you knew you shouldn't have it there.
Yes, sir.
When did Mr. Barone notify you most recently that he'd received a notice from the city?
Don't know which day that he notified me, but he did notify me.
All right, I don't see that I imposed a fine at the last hearing. Well, that was probably my mistake. You know, based on the prior order I entered, it seems that this boat shows up and it's parked and you notice a violation and it goes away and it's parked and notice a violation and it shows up again. And this last time it was there for 9 days. Obviously, I don't think the respondents is taking this very seriously. I'm going to impose a fine today of $50 a day for 9 days. That's $450. And I'm going to set a date for having that boat gone.
It's not there.
By January 31st. If that boat is there after January 31st, fines are going to accrue commencing February 1 at $100 a day. So it's going to get more expensive if you continue to park the boat there.
All right, it is, as he drove by this morning, it's not in that location. It is on the back side of the house.
It was there for 9 days.
July. Yes, sir.
Okay, so the fine's $450. That fine must be paid within 30 days, so it must be paid by, let's say, February 26th. And you'll be receiving an order, Mr. Barong will be receiving an order setting that out. So $450, fine must be paid by February 26th of 2018. The order will tell you where it can be paid. If the boat shows up again there after January 31, I will impose a fine of $100 a day for each day after that date. Okay, thank you. All right, next item on the agenda is case CE 17-002807. Respondent is RDP 7 LLC. The property is 951 Lockwood Boulevard, Oviedo, Florida 32765. Parcel 13-21-531-0000-000110. Alleged violation is a Land Development Code violation, Section 14.8, relating to temporary signs. It's alleged that there was a display of an attention-getting device without first obtaining a permit from the city of Oviedo. Who's going to be speaking to that today? Would you please step forward? Right. And Mr. Orioles, would you, start with you. State your name, please.
My name is Susan Kennard.
What do you get?
Susan Kennard.
Susan.
I'm a representative, a district partner with Arby's Restaurant Group. It's an Arby's building.
Okay, what is your last name again? Spell
Kennard, K-I-N-A-R-D.
Susan Kennard.
Correct.
All right. And you're a representative of Arby's.
Correct. For the development.
Yes. All right. Would the two of you raise your right hand? Do you solemnly affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Mr. Orioles, we'll begin with you.
Yes, sir. Again, I'm Jim Orioles, representing the city. In case 002807, alleged violation of 14.8 of the Land Development Code. I have 20 pages of evidence to present to Your Honor, if I may approach the bench, and I have also supplied those through the respondent.
Yes, would you please? How many pages did you say?
20, Your Honor.
All right. This will be received in evidence as the city's exhibit. All right. Mr. Orioles, go ahead.
The first document, Your Honor, is the property appraiser sheet that shows the ownership of the property is ROC RDP 7 LLC. This is an Arby's restaurant that recently opened. The address is not on the property appraiser sheet. They've gone back and forth with the addressing on this. However, the parcel ID number is correct, 13-21-31-502-0000-0010. The next document for Your Honor is the Section 14.8 of the temporary signage ordinance that states a permit must be obtained prior to erecting and displaying any attention-getting device. The next document, Your Honor, is Florida State Statute 16209 in Section 1 at the bottom. It says, if after due notice and hearing, the code enforcement officer finds the violation to be irreparable and reversible in nature, it may order the violator to pay a fine as specified in paragraph 2A. And at the end of 2A, it says, however, if a code enforcement board finds the violator to be irreparable or reversible in nature, it may impose a fine of not to exceed $5,000 per violation. And we allege that this is indeed an irrevocable and irreversible violation, since once you put up a sign, somebody reads it, it can't be taken down. On December the 9th, we went by the Arby's location. December 9th, they opened the location, and they also opened without a BTR. They didn't, and we're not bringing that before Your Honor today, but this is just an aside to further show that, in our opinion, Arby's had no at all regard for any regulations from the City of Oviedo, and they blatantly disregarded all the violations.
They opened without what?
Without a business tax receipt, occupational license, as it used to be called. We were in contact with the owner of the property several times during the day about both violations, and in fact, they didn't get a BTR until Wednesday of the following week. But the sign violation was first noted on the 9th. They had 7, I believe, swooper flags up, or 5 swooper flags up. And they were given a notice, a handwritten notice that Your Honor will see, that called for violation to be corrected on that day. When it wasn't corrected at about 2 o'clock, I'm sorry, I'm getting ahead of myself. You can also see that there were pennants placed on the light poles in the next picture. And the other pictures are of the swooper flags that were up, both in the right-of-way and on private property, 5 of them. When we noticed at about 2 o'clock that that hadn't been brought down yet, I entered the store with the notice of violation and hand-delivered it to a manager who said that as soon as it slowed down a little bit, it was quite busy in the restaurant, that as soon as it slowed down, he would personally go out and take care of the flags. He would remove them and apologize, and it was very, very nice, very, very professional. I have no problems with his conduct. The next document you see is an affidavit of hand delivery that, in fact, I did deliver that notice to them. The next document, Your Honor, is 162.12, Florida statute, which says all notices required by this part must be provided to the alleged violator by, and in D at the bottom, in the case of a commercial premise, leaving a notice with the manager or the person in charge, which we did. We also, just to cover all bases, we mailed it certified to ROC RDP7 LLC, and the next item you'll see is the green card that was received and signed by them. We also filled out an affidavit of violation, request for hearing, and a notice of hearing. We sent it to ROC RDP7 LLC, and we sent it to Arby's Restaurant, just to make sure all of our bases were covered. I went back to the restaurant on Monday to inquire why the restaurant was still open without a business tax receipt, and the manager, the same male manager who I had spoken with the day before, approached me, apologized to me about the signs being up for 2 days. He said that he didn't want me to think that he was a liar, that he had intended to take them down. However, he was ordered by his superior not to.
So the signs were up on the 8th and the 9th?
Yes, sir. 2 days.
What about the 7th? I thought I saw a picture on the 7th also.
Yes, sir.
So that'd be 3 days.
3 days.
Okay. And they were so the signs went up on the 7th apparently.
Yes,
They
sir.
were given a handwritten notice.
Yes, sir.
to comply on the 8th, and they were still there on the 9th. Do we know if they've been there since?
No, sir, they have not. Our concern is that they blatantly disregarded our ordinances. They had no concern for what our ordinance said. The supervisory personnel there overrode the manager's decision to remove the signs. And our fear is that the corporate person I spoke to on the next week about the BTR told me that, well, when you're doing business, if you get a little slap on the wrist, that's just kind of the way it goes. That he wasn't concerned about it because it was just a minor issue. And we don't consider it a minor issue. It gave a carnival-like atmosphere to the front of the store that our city council has instructed us on numerous occasions they do not want to see. And it took them until Wednesday the following week to even get the BTR. And we just feel like that the past behavior is an indication of future behavior, and we feel like a slap on the wrist will just encourage them to have a promotion, have an anniversary, have a sandwich special, and do something like this again.
So who was it you talked to at corporate that made that remark?
He identified himself as Director of Operations. I didn't write his name down.
Okay, Director of Operations. And that was with Arby's?
Yes, sir.
And what did he say exactly?
That the citizens of Oviedo obviously approved of the restaurant by the business that they were doing there, and that he was not going to hold his managers responsible for minor regressions of our code, and that a minor slap on the wrist was not going to affect them at all. A small fine or a minor slap on the wrist wouldn't be of any effect on them. Well, our fear is, Your Honor, is that they're all of the fast food restaurants, not just Arby's, they have promotions, they have anniversaries, they have sandwich specials, and the total disregard they had for our ordinances at the grand opening tells us that they probably will try to totally disregard us again.
Okay, I'll look at a couple of things here. First, I do find it's a threshold that all the notices required by statute and ordinance have been given. All right. Ms. Kennard, we'll hear from you.
Hi. First of all, the way it works, which wasn't really represented at all, was the fact that our marketing department did pay and did pull a permit for signage. Marketing department handles pulling the permits, sending out all the coupons, hiring the people who come in with the appropriate ladders and the appropriate equipment needed to hang the flags all the way up from the light pole. So therefore, those people also are instructed to be the ones that have to, not my employees, go out there and remove the said signage. But again, we did pull a permit. The marketing department pulls a permit. They also contacted all the city. They also contacted Palm Terrace, Stenstrom Elementary, which we give back to the communities, along with all the other things we get involved in. So again, marketing department handles all that. They did pay pull a permit. You know, when we call, and we got contacted from Rock LLC, who also contacted me and said, hey, can you go represent us because of the fact that we see that you guys pulled the permit, but therefore they're saying that this permit does not include several other permits. I guess you need a different permit for every piece of signage, but when marketing department calls up and they call city officials and they say, what permit do I need for the said signage, when they end up paying for those permits for the said signage. Now, obviously we were wrong, and marketing department contacted City of Oviedo again, and they said, well, no, you would actually need a separate permit for those signs that you hung up, or that you had a company come out and hang up. So, we're going back and forth, and it took us a while to even hear from, they come in and they hand you a piece of paper when we're busy taking care of customers who are very excited to see us in the City of Oviedo. We're overwhelmingly busy, obviously. And like I said, we're giving back to the Palm Terrace and Stenstrom Elementary as part of the funds for those days. So they hand us a piece of paper. We get on the phone with the marketing department and say, hey, I have a permit. Why are they saying I don't? Research is done. They contact, obviously, the vendor or the LLC group that owns the entire plaza, along with the Verizon next to us, et cetera. And they contact us, and we said that we actually need another permit. So the marketing department was supposed to be contacting the City of Oviedo to pull the additional permits. In the meantime, that, I guess, fell through or what have you, but they contacted the company who hung the signs to come back out and remove the signs. So I appreciate the fact that my general manager on site was very compliant and said, I'll do whatever I can do, but we aren't sending employees out there with 15-foot ladders to climb up and remove them. We aren't licensed to do so, and we couldn't do so. Therefore, the time that it took to remove.
Did you ever apply for a temporary sign?
Our marketing department does all that. They handle all the marketing, and this is a marketing event.
Did they ever apply for a temporary permit?
Yes, they pulled a permit. They paid $100 for a permit.
And when did they do that?
He brought it in and showed it to me. I don't have it with me. The gentleman that was there actually showed, because that permit was the sign that said now open. So a company comes out, first it says coming soon, and then it says now open. That instead was the sign that the city said was the only one that the permit was pulled for. So it was very confusing. Obviously, we open up restaurants all over the place, and so every city's ordinances are a little bit different. Just did one at the Speedway in Daytona Beach, not a problem with any of the signage. So, every city's different. Our marketing department isn't flawless. They call up, they call to, pull a permit. And I'm here to represent, obviously, LLC owns that property, and she said to me, could you please go to them and have them look at this piece of paper, because it clearly states that on December 8th, we showed up, or the City of Oviedo showed up on December 8th and was told you have 24 hours to remove them. They came back out and re-inspected on December 8th. So they didn't even give us 24 hours before they re-inspected.
Were they pulled within 24 hours?
Pardon me?
Were the signs?
No, as I stated before, we are not licensed to climb up and remove those. We weren't the one that installed them, and we weren't the company hired to remove or install.
Okay.
We are the people that are inside taking care of the customers, giving back to the community.
Who is ultimately responsible for those signs?
Our Arby's and the actual, the people who own the Plaza Rock LLC.
Okay.
I think they had the same situation might have happened with Verizon next door.
Okay. All right. Anything else?
No, thank
All right,
you.
Ms. Orios, a couple of questions. Ms. Orios, did they ever pull a temporary permit? Well, step to the microphone, please.
They had a temporary permit for the now open sign, and the person that issued the permit explained to them that was the only sign that was available on a permit. The pennants that are in question, that the lady has testified it would take a ladder, I don't doubt that. However, the swooper flags could be taken down in a matter of 5 minutes. We may not even have been here if the swooper flags had been removed immediately, but they were not.
And which signs are we talking about?
The swooper flags,
Okay, the super.
yeah,
okay.
they could be removed in a matter of minutes. I'm not going to contest that possibly a ladder was needed for the pennants. But the notice of violation that was given to the restaurant, I'm sorry that she doesn't think that's a serious piece of paper, but it is very serious to us. And it said, upon receipt of this notice. And the gentleman who received it, there was other people there who completely ignored us, but the one gentleman was very professional, very nice. And the gentleman who received that notice told me he would, as soon as they got slowed down, and I understood they were busy at the time, that as soon as they slowed down, he would go out and take them down. And in fact, he didn't do that, nor were they taken down the next day. They were up for an additional day.
On the handwritten notice, the time for removal was that same day?
Same day,
Not
yeah.
24 hours?
Exactly, yes, sir.
Okay.
So to us, it was just a blatant ignoring of our policies, and they just felt like they were above our ordinances. And the notice of violation, the printed notice of violation clearly says, upon receipt of this notice, and it was understood by the manager, and he totally said, I'll take care of it, just let me get this rush out of here. And we understand that, they have a lunchtime rush, and so we're not being unreasonable. And if it had been just a situation that the pennants were just left up and they had a while to take them down, that would have been understandable as well, but not the swooper flags. They could have been down in a matter of 5 minutes.
Right. And how much does it cost for a temporary permit for an attention-getting device?
$25. But they would only be allowed to have one,
Okay.
not 5.
So they had apparently applied for permits for their permanent signage, but not the temporary.
For the now open sign,
Yeah.
coming soon and now open, whatever. And
So they had gotten that permit.
They had gotten that and they had received that permit. And the regulations have been explained to them when they pick up the permit that it was only good for that one thing.
Yeah, I see two now open signs. One is a banner type, and the other is the, what I call wind-activated one.
Yes, sir, we call those swooper flags.
And so those are the two that were in violation.
There was 5 altogether.
Okay, but the banner one behind it was permitted.
Yes, sir, that's correct.
And what about the ones going up the pole?
Those were the pennants that Ms. Kennard said that they required a ladder, and they didn't think it was safe for their employees to try to take those down, and I can understand that.
Did those require a permit?
Those would not have been permitted.
Those would not have been permitted?
No, sir. No, sir.
So if they'd applied, they would have been turned down on that?
Exactly. They would have been allowed one attention-getting device, period.
Okay.
And also, at that time, they didn't have a BTR. They hadn't bothered to get a BTR. They didn't do that until Wednesday the following week.
Okay. All right. Anything, Ms. Kennard, do you have anything further?
Yeah, just to clarify, I don't understand his terminology. We don't use that same terminology. A swooper, is that what you said? So the now open signs, when they brought it to somebody's attention at the store, it was told to me, our signage,
These are what we call swooper flags.
our permit, were allowed for the now open signs. If you see, these are now open signs. They all say now open. So the misunderstanding was the fact that we didn't, when he said the swooper flags or what have you, those pennants, and these are now open. So we weren't distinguishing it on the same terminology as to which flags were
Do you
needed
have
to
a
be
copy of the
removed.
permit here?
And the business license that he's referring to, we had through our city, and that's not in any of these documents. So he can't keep referring back to something that's not in here.
All right. Do we have a copy of the permit that was issued?
No, sir. No,
Do
sir.
you, Ms. Kennard?
Yes, I can get a copy of it.
You don't have it with you?
I do not
Okay.
physically have it on me. It's on
All right.
One thing I would like to say, Your Honor, is that it was thoroughly explained what flags were to the gentleman. He knew what flags needed to come down. The whole thing needed to come down. There was no misunderstanding on his part that those swooper flags needed to be removed.
Yeah. If they had applied for a temporary permit for an attention-getting device, would I think you had 5 or 7 of the swoopers, would those would have been granted? One? Okay. All right.
Yes, sir. The pennants would not have been allowed, and one swooper flag would have been allowed.
Okay. All right. Well, I'm going to find that there was a violation of 14.8, which lasted for 1 day, 2 days. The thing that I guess concerns me most is your corporate manager's attitude, that this is just part of the cost of doing business. I could make this very expensive. I could impose a $5,000 fine.
Because there's no male district manager. That I don't know who he's talking to.
Well, he says director of operations.
I'm a female that's the supervisor over the area. I didn't speak to anybody personally, but I don't know where he's...
Director of Operations in the Arby's corporate office. When I talked to a young lady named Touche,
She's an accountant in our corporate office, Natasha Storch.
she connected me to, she said the Director of Operations. I don't remember, I think his name was Paul, but I could be really wrong.
There's nobody by that name.
Yeah.
So I failed to understand who she spoke to. I know our director
Yeah.
oversees the whole state, but he wasn't even in the state at the time.
Well, at this point in time, I'm going to make allowance for the possibility that there was some confusion, and I'm going to assess a fine of $300. But these fines can get pretty expensive, so Arby's should be
That's why I'm
a little more,
contacts people,
the cost of business will go up if we get any serious violations. So that should be paid no later than February 8th, and you'll be getting an order to that effect, or RDP will.
RDP, correct.
Okay. And any future violations will constitute repeat violations. Okay, thank you. All right, next we're going to go to the Massey cases on the agenda. First case is CE 17-002179. Respondent is Nicola Fitchner, personal representative for estate of Lawrence O'Brien. The property in question is 1706 Canoe Creek Road, Oviedo, Florida 32766. Parcel number is 19-21-50000-5960. And I note that I entered an order involving this same property back on December 7, 2017, and at that time I set a compliance date of midnight, December 22, 2017. Who's going to be speaking to this item?
I am there.
All right, Mr. Stevens, step forward. Anyone else in the audience going to be speaking to this? All right, Mr. Stevens, please state your full name for the record.
Dave Stevens, representing the city of Oviedo.
Raise your right hand. Do you solemnly affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, sir. What do you have?
All right, Your Honor. Again, this is a case CE 17-002179, 1706 Canoe Creek Road. I have a packet of 4 pages for Your Honor.
All
May I
right.
approach the bench?
Yes, please. All right, go ahead.
Your Honor, you've already mentioned part of this. Your orders were, you found this to be in noncompliance on the 7th of December. It was also ordered that completion be no later than midnight of December 22nd. On December 27th, which was the first day after the Christmas holiday, we were able to re-inspect. The property was found to be in compliance. And the last document in this packet is my affidavit of compliance.
Okay, so they are now in compliance.
Yes, Your Honor.
I will enter an order to that effect.
Thank you.
Thank you. All right. Next item on the agenda is KCE 17-001913. Respondent is Ronald Dodson. Property is 917 North Lake Claire Circle, Oviedo, Florida, 32765. Parcel ID was 14-21-31-MC-0000-3250. And I see that this was the subject of an order that I entered on December 7th regarding a dirty pool, discolored water, and the date of compliance was midnight of December 18, 2017. Who's going to speak to this one? All right, you step forward.
So the respondent is also here, Your Honor.
Okay. Good morning. State your name for the record, sir.
Ronald Dotson.
Okay. And Mr. Orioles, your name for the record.
Jim Orioles.
All right, would you both raise your right hand? You solemnly affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
I do.
I do.
All right. Mr. Orioles, you go first.
Yes, sir. Your Honor, I have 6 pages of documents to present to Your Honor, if I may approach the bench.
Yes.
In the case of CE 17-001913, Your Honor has acknowledged he heard this case and ordered the compliance to be by December the 18th, midnight. Inspection on December the 19th showed that the pool was still green and the panel, even though the picture is hard to see it, but you can see that there's a limb coming through that panel, and the limb in the top of the panel is still in non-repair.
So as I recall, this was the ceiling panel?
Yes, sir.
Okay.
Yes, sir. And yesterday afternoon, this morning, the pool is still in a green condition, and you can see the ladder that's standing up. Mr. Dodson's obviously in the process of fixing that top panel, but it's still in disrepair.
Okay, that's as of 125.
Yes, sir.
So as of 125, the ceiling screen still is open?
Still is open, and the pool is still green.
All right, Mr. Dotson.
Hi, Your Honor. I met with Mr. Orioles, I think it was on the 19th. And I told him at that time I'd made all the repairs that I could. What I couldn't get access to were the large panels. I checked all the Home Depots, all the Lowe's, and they gave me a date, or the local guys gave me a date on when the panels would be in. They came in about, I think I picked them up. I was trying to find my receipt in here, but I thought I picked them up just before the end of the year. I've was thinking of ways to actually Mr. Orioles gave me a suggestion of putting the ladder in the pool in order to get up to the top to put it in. The ladder I have isn't long enough. I tried actually a different way and came up with a solution. The real problem is that I suffer from myelopathy, and so any slight change in the weather, if it's cold or if it's raining, my movement is very limited then. So I was waiting for the warm weather to occur. It came, but then I had the flu. I had the flu up until last week. By then, however, I got my insurance company involved to take care of the matter for me, which is the 2 remaining panels up. The pool itself is not dirty, it is cloudy. I have all the chemicals there. I'll turn it on about every 2 or 3 days. I'm not running it every day because I want to seal up the top to keep the debris from coming in and keep messing up my pool.
When did you begin? You've known since December 7th, or shortly after that at least, that the pool had to be taken care of. Why is it still cloudy? A bit over a month.
It is still cloudy, Your Honor, because I couldn't make the seal in the top. There was always leaves or particles falling down in the pool. I ran it. You could ask my neighbors next door, not the ones that made the charge, but the ones who live right next door to me. I have brought it clean several times, but then it goes back because of the debris that keeps coming down in there.
Did you have some pool people come out to take a look at it?
No, sir. I don't have the resources for that. As far as safety, I put locks on all the doors. I replaced all the lower screens that were missing or that were damaged. Someone's always at the house. And frankly, Your Honor, there hasn't been a kid in my yard in 6 years.
I didn't get that one.
I said there hasn't been a kid in my yard in 6 years.
Here's my concern, Mr. Dodson.
Yes, sir.
As an attorney, I was involved in a case a couple of years ago. Homeowner let his pool get very cloudy.
Mm-hmm.
He rented the house to someone. Beautiful little 2-year-old child named Sunshine moved into the house with her parents. Her grandmother was out walking the child, and all of a sudden she lost track of the child. They couldn't find the child. They looked everywhere. Finally, a teenager dived into the pool and pulled the child out. But by then, she was brain damaged. Cloudy pools are dangerous. They are just dangerous. And that's not the first case I've seen with that. So, it's a real cause for concern.
I understand.
That concerns me more than the roof screen. I don't want to add to your financial problems, but this has got to be corrected.
I understand.
If I give you a little more time to correct it, can you give me a date when it will be corrected?
What's today? Thursday?
Today is the January 25.
I'll have it corrected by Monday, Your Honor.
Right, I'm going to give you till February 9. And that's midnight. Now, Mr. Dodson, as reluctant as I am to add to your problems, if it's not corrected by midnight of February 9, when we get back to the hearing next in February, I will impose a fine of $50 a day for every day after that it's not repaired.
Yes, Your Honor.
So, Mr. Orioles?
Your Honor, just a point.
Well, speak into the microphone if you would, Mr. Orioles.
Just one point. February 9th correction date would mean we would not be able to inspect that until February the 12th.
When is the next meeting?
Next meeting is February the 22nd. We have enough time to get, we have plenty of time.
February 12th then?
Yes, sir.
Okay. We'll give you to February 12th, Mr. Dodson. But I'll be very reluctant to impose a fine on you, but I'll have to do it if this comes back before me
I
in
understand.
February. Okay, sir. Good luck with it. Get it done.
Thank you.
Thank you. All right. Any other business to come before us? All right. There being no other business to come before us today, we are adjourned.